In this video clip today, we are going to see the powers, functions and duties of the trustee. In other way, we can say the rights, liabilities and duties of the trustees and beneficiaries. When we see the trust ordinance, the sections divided into different categories. Section 32 to 47 of the trust ordinance provide the duties and liabilities of the trustees, and section 48 to 56 of the trust ordinance deals with the rights and powers of the trustees. Section 48 to 56 speak about disability of trustees. Finally, section 57 to 71 provides the rights and powers of the beneficiaries. What is trusteeship? Trusteeship is like a volunteer service, subject to several restrictions and limitations. In terms of section 52 of the trust ordinance, trustee has no right to remuneration for his trouble, skills and loss of time in executing the deed of trust or trust. It doesn't mean that remuneration should not be paid to the trustee, but as a right, trustee should not claim any remuneration. But under the provisions of the trust deed of trust, or under directions of the author of the trust, or even in a separate agreement between the trustee and the author of the trust, remuneration may be paid to the trustee. Trustee must not use or deal with the trust property for his own benefit or profit. Always the trust property for the benefit of beneficiary. If the duty of the trustee to sell the property, then the trustee should not buy that property directly or indirectly. Sometimes it happens the trustee nominates some other person as an agent. The agent will purchase the property on behalf of the trustee. That also prohibited. In addition to that, not only the trustee, even no person who has recently ceased to be a trustee may, without court permission, become or buy the property or become mortgagee or lessee of the trust property. The court may permit, if it is beneficial to the beneficiary, then the court may permit the purchase. Otherwise, the court will refuse, because everything for the benefit of beneficiaries, not for the benefit of trustee. That's a limitation or restriction is there. Further, we will see trustee must be bound to fulfill the purpose of the trust or deed of trust. In addition to that, the trustee must give effect to the deed of trust and the directions given by author of the trust. Then he must obey the directions of the author of the trust. But these principles or the concept behind these deed of trust is something that's the intention of the author of the trust. Then every time trustee is obliged to give effect to the intention of the author of the trust. It can be modified with the consent of all the beneficiaries. At that time, we must consider whether all these beneficiaries are competent to conduct. That means whether they attained the age of majority. And further, we can say the trustee is bound to maintain and defend all the cases in relation to the trust or deed of trust or trust property, and also to preserve the trust property and protect the title. Section 15 of the trust ordinance is very important. It provides that the trustee must deal with the trust property as carefully as a man of ordinary prudence would deal with such property if it were his own property. Then the test is something as it were his own property, he must act. In addition to that, if the trustee is so dealing as it is his own property, if the trustee is so dealing, then he is not responsible to any loss. Then suppose 1 million rupees given to the trustee. Then the deed of trust provides that it should be deposited in a place where you can get more profit or more interest. In that case, the trustee deposited the trust money in the finance company. The next day, the finance company collapsed. But at the same time, he deposited his own money in a very government guaranteed bank. That means he did not act as reasonable ordinary prudence man, and also he did not act as it is his money, because he has deposited his money in a government guaranteed bank, but he has deposited this trust property in a financial organization or wherever. Then that's the test here. He must deal with the trust property as it were his own property. Then further we can say, if the property is waste in nature, then the trustee must convert the property into the property of permanent and profitable character. This is one of the duties of the trustees. If there are several beneficiaries, then the trustee should not be partial. That's the constitutional provisions. Article 12(1) of the Constitution provides that every person are equal. And the protection must be given to the person. Equal protection must be given to every person. Then there should not be any discrimination. Here also the same way we say that there should not be any impartial treatment to the beneficiary if there are so many beneficiaries. Then the trustee must keep clear and accurate accounts, and also must furnish the beneficiaries the full accurate information. That's one of the very important accounts of the profit as well as the trust property. A trustee commits a breach of trust, then he is liable to make good the loss sustained. A trustee who is liable to loss occasioned by breach of trust in respect of one portion of the trust property cannot set off against his liability a gain acquired from some other portion. Now suppose he has deposited money in one place and earned some loss, and further he deposited another portion of the money in another profitable place. Then he can't set off this loss from the profit. Whatever loss occurred, he must make it good. That's why the section provides that any trustee who is liable to a loss occasioned by a breach of trust in respect of one portion of the trust property cannot set off from any profit earned from other portion of the property. Further, there is another interesting part now we must discuss here. The new amendment. The Amendment Act number 6 of 2018 introduced very recently. Then in that act there are some more duties given to the trustee. When you see that section 6 of the Trust Amendment Act, section 6 of the Amendment Act number 6 of 2019, every information in relation to the movable or immovable property should be furnished or given to the Registrar General. That's one of the very important. And section 19A, the 19 also one of the important section they highlighted again in the amendment to keep the proper and accurate accounts. And 19A, that's very important. All the information in relation to the property, owner of the trust, trustees, beneficiaries and manager, whoever involved in the trust should be given to the registrar general. If you don't give, what is happening? If you don't give, the trustee must give those things, otherwise he commits an offence, punishable by 200,000 fine, not exceeding 200,000 fine, or 2 years not exceeding 2 years imprisonment. Now, under Amendment Act, there are some obligations or duties imposed on trustee. If he fails to comply with that one, he commits an offence. Now we will see the rights and liabilities of beneficiary. We don't see the whole section in the trust ordinance, it's impossible to see here. Then we are going to see only the main section. Then when you see the rights and liabilities of the beneficiary, that's another thing. The beneficiary has a right to rent and profit of the trust property. In addition to that, he is entitled to have the intention of the author of the trust executed. Now, when you see section 11, we have seen author of the trust given the trust deed to the trustee. The trust deed is executed by author of the trust and given the duty to implement all these things to the trustee. Then the trustee, as a duty, he must implement the intention of the author of the trust. Here, in other way, the beneficiary is entitled to have the intention of the author of the trust executed. And further, the right against the trustee to inspect deed of trust and other accounts. Beneficiary has a full power to check the deed of trust as well as the accounts. And further, the beneficiary has a right to the beneficial interest. That's the ultimate purpose of this law of trust. And also, beneficiary has the right to compel the trustee to perform the duty. If he is something avoiding or he is avoiding to do something, then the beneficiary has a right to file an action and ask the court to compel the trustee to do certain things. And further, we can say, if the trustee wrongfully purchases a property, then the beneficiary has the right to have the property declared subject to trust. Or sometimes, if the beneficiary is willing to get the property back, then he can ask the property to transfer to the beneficiary. Then these are the powers given to the beneficiary to execute the deed of trust, or sometimes we can say to implement or execute, to implement the intention of the author of the trust. If the trust property wrongly goes into the hands of third person, the beneficiary institute an action for the declaration that such property is subject to trust. Further, if the trustee disposed or sold the property to third person and received consideration, the beneficiary has some same rights over the consideration. The original rights, whatever given to him on the original property, the same or similar rights he has in the converted property like consideration. Then further we can say here, if the purchaser brought the property, if the purchaser purchased the property in good faith without notice of the trust, that's a difficult situation. It defeats the rights of the beneficiary. Because the purchaser is a bona fide purchaser. He doesn't know anything about the trust, and he doesn't know about that he has the good faith in purchasing that property. In those cases, beneficiary has no right to write on such property. What he can do is he can follow the proceeds of the sale, and he can ask the court to declare that he is subject to trust. Finally, we will see the trustee mingles the trust property with his own property. Sometimes if the trust property is, say, suppose it is given 1 million rupees, he has put that 1 million rupees with his own money in a deposit and deposit in the bank as a 2 million rupees, then the beneficiary is entitled to a charge on the whole fund, 2 million rupees, for his amount due to him. Then these are the main ideas here. We have seen now the rights and powers of functions and duties, liabilities of these trustees as well as beneficiaries. That's we have seen now. Now whatever we have seen in these video clips, now we have seen so many video clips here, everything's just a guideline. It is not enough to write examination or the answers in the examination. Then what you should do is, there's a link, there's a site, website link down here, then you can go to that one and you can read this PowerPoint presentation. In addition to that also, I don't say that that's enough. In addition to that, you must refer 1 or 2 books for wide knowledge. Then only you must be able to write these answers in your examination. That is the end of law of trust. Thank you for cooperation until this time.